Okay, welcome. I think this is going to be more of an evolution of discussion because some of the earlier panels have touched on these topics already. And so we're going to dig into some different aspects of efficient infringement, which is essentially court decisions, law, and policy changes that have conspired to make infringing a patent the most rational and, in fact, legal approach. Rather than actively seeking a license. And our panelists have been working on some really interesting empirical research, and they're going to share some of their results this afternoon. So in the order that they will be speaking, Kristen Oswego, Austin E. Owen Research Scholar and Professor at the University of Richmond School of Law. Then Jonathan Barnett, the Tori H. Webb Professor of Law at the USC Gould School of Law. And third, David Kapos, former Undersecretary of Commerce and Director at the USPTO, and currently a partner at Cravath. So the panelists are going to have around 15 minutes to discuss their key findings. I will then provide some comments, and after that, we will turn it into a discussion. And during that discussion portion, I'm hoping that the audience, both here in person and online, will join in. So with that, I'm going to turn the mic over to Kristen.
Okay, great. Thanks, Anne, and I also want to thank Jonathan and SIP Squared for inviting me. As Anne noted, we're going to talk a little bit about things that have come up and been touched on, but I think this panel is going to go into a little more detail, and I'm going to take things back and give some background on efficient infringement for those of you who maybe haven't been paying attention for the last 15 years. But also, one of the things that came out of the first panel was that, maybe we just need to follow the law. Maybe we just need to apply the eBay factors. And so I think if we're going to be thinking about that as a solution for efficient infringement, we should probably talk a little bit about those eBay factors again. So I know you all know them, but I'm going to talk a little bit about that and then also talk about a project that I've been working on that Anne alluded to. So I want to start with this quote that was in the New York Times by Joe Nocera in 2015, where he basically is filling us in on this new dangerous thing, efficient infringing. So big companies can now largely ignore legitimate patent holders. Of course, they don't call it stealing. A new phrase has emerged in Silicon Valley, efficient infringing, because courts have largely robbed small inventors of their ability to seek an injunction. The worst that can happen is that the infringer will have to pay some money. And for a rich company like, say, Apple, that's no big deal. Well, that tracks a lot with what we've heard this morning. But one thing I want to highlight there is we also heard Curdy tell us that sometimes it's big versus big. It's not always the small inventor that's on the other side of this efficient infringing. So I think this is kind of cute. It's very cute in 2015 that he said this is this big new scary thing. But I like it as a quote. Now, here's my actual favorite quote. Efficient infringement is an attempt to make infringement seem appropriate. It is not. I could just end right there, and that would be all I would have to say. So taking a step back, I'm a law professor. I can't help it. We're going to just go back to basics for a little bit. In the good old days, and by good old days, I mean before eBay, we would have a normal course of infringement. The patent owner would sue. A court or jury would determine the patent is infringed, is not invalid. The remedies that would be available would be damages, and then an injunction. And that was good. And it was good for a couple of reasons. It set up a good set of behaviors that we would like to happen, right? An infringer who fears injunction might actually negotiate before they start infringing. Or maybe if you're afraid of an injunction, if a lawsuit gets brought against you, you would settle, maybe before the lawsuit even starts, right? And injunctions, as I always tell my students, doesn't mean actually that the infringer is going to stop infringing. It's just providing a place for post-litigation negotiations to start from, okay? So that's the good old days. Efficient infringement, on the other hand, happens now. And so another little piece of that quote from the Joe Nocera piece, efficient infringement is this relatively new practice of using a technology that infringes on someone's patent while ignoring the patent holder entirely. And so what we're looking at with efficient infringement is this idea that it makes a lot of sense to infringe now and negotiate later. Or maybe don't even negotiate later, just wait to get sued, okay? And in the worst case, the worst thing that could happen is we've heard a couple times this morning the infringer, if they're found to be infringing after the fact, they pay damages for their past infringement like they would have in the past, and then they just pay a royalty going forward, which is what they would have done if they had taken a license, okay? That's the worst case. There's a best worst case, and when I say best, I mean worst case. That best is in sarcastic font, okay? So the best worst case for your infringer is that the rate that they get saddled with during the course of the lawsuit is actually less than they would have been able to get in the negotiation ahead of time. So not only do they get this 5 to 7 year interest-free loan for infringing, but then they end up paying less than they would have paid to start with, okay? And so if you're an infringer, this seems awesome, okay? If you're a patentee, this is not awesome. Okay, so why is this a thing? And this is part of what I wanted to go back to based on what they said about the first panel, right? So this is a thing because of eBay, 2006. Basically what we're saying here is that eBay is almost old enough to drive, which is pretty wild. It's a long time, and I have some interesting things to say about that. But what eBay did, and what we heard Scott say over lunch, is that eBay came up with this out of whole cloth, maybe, we don't know, it doesn't matter. Here's the law of the land. We have these 4 factors that we're supposed to weigh when we are deciding whether or not to issue a permanent injunction, and here they are. There has to be an irreparable injury that has to be causally nexus related to the infringement. Federal Circuit's kind of fleshed that out for us. The remedies at law, by which they mean damages, are inadequate to make the patentee whole. We need to look at the balance of the hardships because injunctions are supposed to be equitable. And then we have to take into account the public interest, okay? And so what we heard from the first panel is maybe if these 4 factors are just applied fairly and right, maybe we're okay. I don't know, maybe not. Anyway, more interesting than the majority opinion in eBay is the Kennedy concurrence with which Stevens, Souter, and Breyer joined, and we get the 3 boogeymen of patent law. You didn't know there were 3 boogeymen of patent law? There are. And what you hear is the dangers. The dangers for patent law are patent trolls, small components of big devices, which is where SEPs come in, and business method patents. Those are very scary, and that's why we can't have injunctions, okay? I'll also say, too, in looking at some of the data I've been looking at, we also see a lot of times that SEP owners are also patent licensing firms. So, but SEPs jump into this in 2 different spaces. And these are the problems that we see why we shouldn't have injunctions. Okay, so when are we not seeing injunctions? Well, when you would expect, during the boogeyman, okay? Patent licensing firms don't get injunctions, okay? They're also known as patent trolls. I'm not calling them that. But we also, and for the purposes of this conference, have this idea that if it is an SEP that's being asserted, they should not get injunctive relief, okay? And there's a bunch of reasons for it, okay? So we have the FRAN commitment that we heard about earlier. If you agree to license the patent, then why in the world should you get an injunction, okay? We also have antitrust policy. We also heard about that this morning, right? We have the 2013 FTC DOJ guidelines, and we have the new executive order that President Biden issued this summer saying, hey, maybe injunctions shouldn't be issued, right? We have policy within the standard development organizations themselves, right? We have the 2015 IPR amendments by IEEE. They're like, hey, injunctive relief, probably not going to be available, okay? And the reason for all of this, we're told, is holdup. Well, I'm not going to tell you what holdup is because we've already heard what holdup is. But we're told patent holdup is why we can't have injunctions in cases. We have a little but-see there of that 2019. They talked about it this morning. I'm not going to belabor that point. Okay, so is it real? This gets you to my project. Not an economist, so when Anne said I do empirical work, it means I count things. I don't equation things.
I was being generous.
Thank you. I appreciate that. I count things. So what I've done, and part of it is inclination. No, it's not. It was a Twitter war. There was a Twitter war. And somebody said something about efficient infringement, and somebody said, that's not even real. That's not happening. I'm like, yeah, okay. So I started digging into injunctions. Now, a bunch of work was done in the first few years after eBay to see if it was changing how things were happening, Okay, there was a really nice piece by Chris Seaman. There was another piece by Jay Kaysen and Kirti Gupta that we heard from earlier. Another case by Mark Lemley and Colleen Chen, a couple of professors. And they started looking from 2006 to 2013, did eBay change anything? And the answer was yeah, it actually did. Okay, and so I wanted to look at, well, what happens after 2013? And then also their focus was largely patent licensing firms. They were like, they classified all the patent asserting companies. Are they patent trolls? Are they not patent trolls? And so I was looking more deeply into to see what I could see about standard essential patents. And does that affect what's happening? But also on patent licensing firms, because like I said, that they still come into play when we're talking about SEPs. Another professor is also currently doing a lot of the same work, George Contreras. He and I basically like started down parallel tracks, and then like my train went that way and his train went that way. But the nice thing is our counting matched. So that's good. So I have a little bit of backup for the counting, but what he decided to make of those numbers is something entirely different than me. Okay, so this is simply looking at patent cases from district courts that were litigated between the date of eBay and 2020. Now, you'll see 2020 is little tiny numbers. Why? Pandemics. These things happen, okay? But what you will see is that, yeah, basically, there's still a problem with injunctions not being issued. Editorial. I think it's a problem that injunctions are not being issued. And it is still true, even after all of the research that stopped in 2013, it is still true, 2016 through 2020, that injunctions are not issuing as often as I would like to see them in cases of patent infringement. Okay, so these are cases like Scott said during lunch, where there's already been a finding of not invalid and where there's already been a finding of infringed. We've already decided who is the bad guy, and they are bad, and we're still not going to stop them from doing it. Okay, so these are still preliminary numbers. I'm double checking them. I got RAs working around the clock. They have exams, so they're not working really hard. It's okay. So I looked at the total number of patent infringement cases where injunctive relief was disputed, so not where they agreed or settled or anything like that. Got myself 342 cases. This is me counting. Okay. The numbers for grants versus denials, I have 249 grants. I have 93 denials. That's a 73% grant rate. That's still really high. No, it's not, because it used to be 99%. Okay. And that's held true. So before 2006, it was about 99%. All of the research that stopped in 2013 got to between 72 and 80%. Those were those three other studies. If you carry it out to 2020, the number stays the same. Okay, we're still looking at 73% with a variation between 65 to 80% by year, but it's really small numbers, so that doesn't matter, okay? They're really small numbers. So very consistent with these other numbers, and like I said, it matches Professor Contreras's, who's done something similar but then different. There's a lot of limitations, which is why this is not really an empirical study. This is just me counting things. There's a ton of issues with the selected effects on litigated cases, and more important than that with respect to SEPs is that the choice of the patentee in those cases is often to not even seek injunctive relief for a lot of reasons, okay? Whether it be the IEEE policy, whether it be why bother litigating something we know we're going to lose, whether it be, we've seen the writing on the wall from these other cases. Anyway, so a lot of times what we are seeing in SEP context is they're not even asking for injunctive relief, okay? Okay, so I have a very, very, very small N. It's like a handful of cases, that's it. Couple denials, couple of grants, okay? Because what I'm also seeing is looking again through these cases where we get a patent infringement case that goes to decision, which is again a selection effect all in itself, right? Most SEP owners are not seeking injunctive relief, right? You read their complaints, you read their amended complaints, all they're looking for is damages. Now, they're often looking for a willful bump. I'm not gonna say any more about that because I know Jonathan and David are, okay? So I'm wondering myself, is that a proxy for efficient infringement? I'm still playing with it, that's all I'm gonna say, okay? But what I wanna talk about is what I did see, okay? And I know I only have a few minutes left, but what I did see is this. First of all, in the very few cases we have where a district court has looked at a case that involves an SEP where infringement was found, the very first place their head goes is hold up. Hold up, remind you, hold up is not one of the eBay factors. And yet that's the first place they go. Very strange. Maybe the first panel was onto something. Maybe we just need to get hold up out of the judge's head and say apply the eBay factors, okay? Then they go to where we would expect them to go. okay? And the thing that makes a lot of sense is the first two eBay factors, right? Is there irreparable harm, and would money damages make you whole? Now, that's not just a guarantee, right? That's not a done deal, you got Fran, done, you lose, right? It shouldn't be. It is, but it shouldn't be, okay? Maybe if they actually looked at, well, let's talk a little more about what irreparable harm looks like. Let's talk about whether the Fran really means money damages make you whole, okay? And then there's a weird place that these cases go, which is the public's interest in having fun technology. No. The public has an interest in a strong patent system, but actually some of these cases, it's like, yeah, but the public really wants their phones, which goes back to one of the things that Scott said over lunch, which was the NTP versus RIM case. Man, we want our BlackBerries, right? Same thing is happening in the SEP space. In these very few cases, again, not enough to make a point about, but the courts are saying, yeah, but the public wants those toys. Okay, so I'm just very briefly, in the last few minutes I have left, going to talk to you just about a few cases to show you kind of give you an example of some of the things I just mentioned that I found, okay? Now, Hynix versus Rambus, okay, I get it. That case is a disaster of a mess of a case with all kinds of bad behavior. That's actually what I want to talk about. Don't want to even talk about it, okay? What I want to talk about is a little tiny part of one of the opinions in that case. That case went on for 9 years, okay? There's a little tiny part of one opinion in that case where they talk about whether an injunction should issue, okay? That's the only part I want to talk. I don't want to talk about the rest, okay? And so the court actually begins by recounting the eBay factors. So one of the things that's interesting is I'm reading all of these 342 cases and stuff like that about where they're talking about injunctive relief is whether they look at the eBay factors. Now, most of them do, good. That means courts are doing their job. That's nice, okay? But there's another strand of cases that says basically permanent injunctions for patent infringement should be incredibly rare. I'm like, where the heck did that information come from? And then there's this like line of cases and they just keep citing it over and over again. Didn't come up in the SEP cases, but it was totally interesting. No, it shouldn't be totally rare. eBay doesn't even say it should be totally rare. Okay, anyway, so in this case they didn't. In the Hynix versus Rambus case they didn't. They recounted the eBay factors, and immediately after laying out the eBay factors, they entitle a section of their opinion, "Injunctions should not encourage holdup." That is the first place they went. They listed off the 4 eBay factors and they said, oh, hold up. Oh, buddy. Okay, now, interestingly, in that case, they didn't actually talk about patent holdup like we've talked about today. They went back and they talked about 2 very, very, very old cases, and when I say that, I mean like 1880s, and talked about about patent holdup and how injunctive relief can be disproportionate and it's bad and stuff like that, which is kind of interesting, but you're like, why did you even go there? Like, first of all, why did you go holdup? And second of all, why did you go to 1880? This doesn't even make any sense. Anyway, so then they apply eBay, just to, give you that. And they got to this idea about money damages. No, irreparable harm, money damages, what the court says is, Rambus doesn't actually sell anything, as we saw. They're a patent licensing firm. And so they're not losing sales, but what was happening in that case was competing standards, which is kind of interesting. And what they said is any sale made by Hynix is a sale for a standard. It's another vote for a standard, which is not the one that Rambus's technology covers. And so basically, they're talking about a de facto standards war playing out in the market, okay? And they're saying that actually could be irreparable harm. Because if there are enough votes go over here, Rambus's standard's gonna lose out, nothing's gonna happen. Court disagreed with everything else that Rambus argued, but they said, hey, that's a good point. It's about this big. It's about this big. And so instead, they said that, Rambus really just wants money, and the idea that they might lose the standards war playing out in the market, pretty small. Therefore, money damages are fine. No injunction for you, okay? They did also mention something else interesting, but they didn't do anything with it, which was loss of goodwill, which is another thing that we oftentimes see in the injunctive case space, where if there's a loss of goodwill, that's an irreparable harm that can't be made whole by money. The court actually mentions it in the Hynix case, but then they don't go anywhere with it, and it's kind of a little sad. And they spent a lot of time comparing this case to the Broadcom versus Qualcomm. Okay, so in the interest of time, I'm gonna skip over Apple versus Motorola, but just mention there that, in that case, at least one of the judges said, if you even try to get an injunction, you are breaching your duty of good faith negotiation. Whoa, okay, that's scary. Okay, last one I want to talk about is the Cesaro case, or the Cesaro case. And oftentimes, when we talk about this case, we're looking at it as a patent troll case. Like, you're like, oh, does a patent troll ever get an injunction? Oh, yeah, they do in Cesaro. You know what? It's also a standards case. which most people don't pay attention to because you're so excited that a patent troll once in a lifetime got an injunction. Anyway, so they're not really a patent troll. Cesaro is a research organization arm of the Australian government. Think RNIH or NSF. They got a patent on WLAN technology. IEEE reached out to them and said, hey, will you make this available on FRAND? They said, yes, we would. So here, we got our SEP case. We got our FRAND commitment. Everybody's like, patent troll. But there's also an SEP case going on here too, okay? Anyway, so they sued for infringement. Again, we get to the point. Buffalo Technology is a bad guy. They infringe. The patent's not invalid. The court applies the eBay factors. And the argument that Cesaro makes is it's hard for us to make other companies take a license from us when other people are infringing over here. So if we let them do this bad behavior, then we are ultimately going to be hurt in the long run. Well, that would apply to almost every SEP owner, right? And the court in the Cesaro case found that to actually be kind of compelling, right? Also compelling is the fact that they throw their money back into their R&D, okay? And if you can't get licensing money or as much licensing money as you think you're going to get, you can't throw it back into your R&D, there's going to be less research, less innovation, everything really bad is going to happen, right? And so that was why they, in the end, said there is irreparable harm here. There's irreparable harm to your future opportunities. There's irreparable harm to your reputation. You're going to lose out on your R&D. And the public has a strong interest in a strong patent system. So that was good. One other thing that tweaked it, which is kind of brings us back to the eBay boogeyman before I sit down, is that in that case, the court also said what Buffalo Technology is doing is not a small piece of a big product. But the patent they were infringing was actually the product. And so there's a difference when we're thinking about the Cesaro case and how that would apply to other SEP owners, even if they're not super sympathetic, like being the Australian research group, is the idea that it wasn't a small component of a very big product, but the patent covered the whole thing. So anyway, my time is up. I'm going to sit down because I know Anne has interesting questions for us.
Let's move straight to you guys, and then we'll have a discussion all together. Yeah.
All right, it's a pleasure to present this joint work that I've been working on with David Kapos, and I've learned a lot from David. I hope David's learned something from me. And our objective in this paper is both critical and constructive. So we're going to tag team here. I'm going to be critical. David's going to be constructive. Critical is to identify in a reasonably precise way the inefficiencies that have crept into the patent system and the innovation markets on which it relies as a result of the deterioration of the ability to enforce patents through injunctions. And the constructive part is going to be our elegant remedy of how to fix that, taking into account current political constraints, meaning we are only considering politically feasible solutions. All right. So we've been hearing a lot about eBay. I think today eBay is so huge that it's hard to remember that at the time it wasn't necessarily a headline decision. It might have been interpreted, at least if you were only looking at the 5 justices who did not sign on to the Kennedy concurrence, that it gave a tool to courts to address a special case of opportunistic patent litigation, but otherwise the longstanding historical presumption, which, contrary to some of the language in the court's opinion, it had never until eBay ever been the case that if you are a patent owner and you establish validity and you establish infringement, that you wouldn't be entitled to injunction 99% of the time. The patent system, even when it had been harsh on patent owners, had used other tools. It had never touched the third rail of the right to injunction. That's why eBay is important. Now, the reason eBay became so important is the expansive way in which the lower courts have interpreted it, so that as a practical matter today, it's no longer a special tool for non-practicing entities who are undertaking opportunistic litigation. It includes all non-practicing entities. It includes all standard essential patent owners, which if you either count the number of the patents or the value of patents is a huge portion of the ITC markets. And under a fair amount of case law, it is going to capture any holder of any patent on a component technology in a multi-component product. If you would like to point out to me an electronics product today that does not fall into that category, please let me know. So what we've essentially done, without any legislative discussion into economic cost-benefit analysis, public comment notice, none of that stuff. What has happened is that we have, through court decisions, moved our patent system from being something that is reasonably close to a property rights system to a quasi-compulsory licensing regime. Okay? And that was designed to address the special case of opportunistic patent holdup. Whether or not we think that was a useful tool, what has happened is a result in the market, and we can easily observe that, is that large implementers of technologies, those who tend to be net payors for IP assets, have responded in a perfectly rational way. If they were to do anything differently than what they're doing, they would be an MBA case study in how not to use IP. And as the head of patent licensing himself at Apple, or former head of licensing at Apple, himself observed, it would potentially be a violation of the legal duty of a corporation to maximize shareholder value if they decided to voluntarily enter into a license for a patent rather than litigate it. Okay? Now, what we want to do here is we want to build on that intuition, and we identify specific circumstances in which this would be true. So we're not at all saying that all patents are worthless, that no one is going to license. We want to identify in a more precise way when, in fact, what the head of former head of patent licensing at Apple said, when will that be true? In a regime in which there is no realistic possibility for the patent owner to secure an injunction, even if they're successful in a patent, right? So they have no credible threat to stop access to technology. When will it be rational? When will it be your dominant business strategy to say, no, thank you, sue me in court, I'm going to continue using your technology? One, it has to be costly to develop a design around. Okay? If I have a costless design around, I'm not going to bother with litigation. Two, I have to sit on a pile of cash so that I can fund the litigation for a long time. And even better, my pile of cash should be quite a bit bigger than yours. Okay? Second, third, I have to be assured that throughout this litigation, I'm always going to have access to your technology. It's very important to understand the effect, the asymmetric effect that this has on the litigation dynamics and on the settlement bargaining that is taking place concurrently, or even if there isn't a litigation, the negotiation dynamics. Just think about this for a second. It may be obvious, but it's important to nail it down. Throughout the litigation, throughout the years of litigation, the infringer has access to the technology and is earning money off of a technology that it invested $0 to develop. Whereas the entity that invested all of the money and took all of the cost to develop that technology is earning nothing. On top of that, it is also common that the patent owner has no other significant revenue streams during that time. And it is also common that they also have a much smaller cash pile to fund the litigation. Okay? The fourth condition is that in the downside, in the worst case scenario where I lose the litigation, the damages will be determined based on a reasonable royalty methodology that is designed to replicate the royalty that I would have paid anyway. So what happens in that case? Now I got to use your IP through the whole litigation. I'm paying you the same amount I would have paid anyway, so I just got all of the time value of money. And the fifth condition, which is one that we want to focus on and get some more information to be sure how often this is satisfied, and we don't have perfect information, is that there has to be a sufficiently low likelihood that we're not going to be hit with enhanced damages if we lose. If all of that is true, then the fees that we're paying to a lawyer, and the fees are often, the litigation costs, that they're very high and it's a great burden on society. They're actually quite low proportionately relative to the stakes, to the amount of money that is at stake in these litigations. And what are the litigation fees if all of these conditions are reasonably satisfied? They're just an option fee. An option for what? An option to potentially invalidate the patent, or even if the patent is upheld, to receive a reasonable royalty damages that is lower than you would have paid in a negotiation, or in the most likely outcome, you reach a royalty rate through settlement that, given the asymmetric bargaining dynamics that I just described, is almost certainly going to be lower than the royalty rate that you would have negotiated up front. And that is why the former head of licensing at Apple was absolutely correct, and I 100% agree with him, that it would be irrational for a company like Apple today to take a license for a patent that falls into a technology sector where there's no real possibility of an injunction. It's hard to believe that the justices in eBay had contemplated this scenario. Okay. Now, I say efficient infringement in quotation marks, and Kristen did the same thing. And why? It has to be in quotation marks, because when economists say efficient, they mean Pareto efficient. Pareto efficient means that at least one party is better off and the other party is at least made not worse off. That's not what efficient infringement means when they're saying that in Silicon Valley. That just means it's efficient for me and inefficient for you. Okay? But what it's important to understand is that so-called efficient infringement is inefficient for everyone except that individual innovator at that time. There are a couple reasons why this is likely to be the case. The first, which has been talked about a bit in some of the previous presentations, is that in general, a patent system where you don't have a high possibility of injunctive relief, or just to make it simple, let's say you have none, is going to tend to advantage systems-based companies that have non-IP assets like economies of scale, economies of scope, internal funding. This was all observed back by David Teese in 1986. All of those non-IP substitutes for IP, large established firms tend to have them, and startups or big firms that rely on licensing don't. Okay, so what you've just done is you transferred wealth from startups and entrants to incumbents. That makes absolutely no sense as a matter of competition policy. The second thing it does is the reverse of what the justices explicitly anticipated in eBay. They take away the injunction, and then we're going to have less litigation. No, it's exactly the opposite. If you take away the injunction, then Apple, Google, and so forth, why in the world would they not litigate against you? They have more cash resources, and they get to use their technology. So we discourage settlement, we encourage litigation, we increase litigation costs. Again, that also makes no sense. The third thing, which I think is actually perhaps is the most worrisome of all, one of the functions of the patent system, in addition to incentivizing innovation, is to take new technologies and stick them in what I like to call a property envelope. When you stick them in a property envelope, now the market can start attaching prices to those different assets. And in fact, the price that they attach to most assets is actually close to zero. Okay. Now, when you take away the injunction, when you touch that third rail of the patent system, you've just interfered with the ability of the market to price out the asset. Why is that? Because if I'm the patent owner and I'm negotiating with a potential implementer who satisfies all of the conditions that I showed you on the previous slide, the royalty that I can negotiate has just been distorted. And it's been distorted in a systematic direction in favor of the implementer. So that what we should tend to see is that as long as we think that the patents that are being issued by the Patent Office tend to be valid, patents consistent with social optimality, all of the prices are going to tend to be underpriced. We're undeterring infringement, we're undercompensating patentees. Okay? This has another consequence, which is that even the patents that are taken into court and where the patentee wins, and they can't get the injunction, you might say, oh, the monetary damages are going to make them whole. No, they're not. Because the typical methodology that is used correctly, the typical methodology that is used to determine patent royalties is comparable royalty rates. But the comparable royalty sample set has just been corrupted because all of the rates that we observe in the market have been distorted in the downward direction that I just described. So we're going to get systematic undercompensation, underdeterrence when you live in a no injunction world, and it's inefficient. And it actually has, we don't usually talk about from an economic perspective on distributive effects, but I'll just observe it does have a distributive effect, which is regressive and it's anti-competitive because it tends to take wealth away from innovators and to implementers. From innovation and competition policy perspectives, again, makes no sense. Okay. All right. I'll run through this a little bit more quickly because I'm starting to eat into your time, David, because I'm only about half. Okay. So, very quickly, The last condition that I identified, that in the circumstance where it is rational to infringe, and again, let me underline, it is not always rational to infringe. In the life sciences, it's not going to tend not to be the case. Okay, but the last condition was that the implementer needs to have a reasonably low likelihood that they won't be hit with enhanced damages. Okay, and enhanced damages can be attorney's fees or so-called treble damages for willful infringement. If you look in the statute, they're reserved for exceptional cases, and that's probably true for attorney's fees. In treble damages, there's not a lot of data out there, and it uses different methodologies, so it's not entirely satisfying. Okay? But we do see some common trends among the data. And the thing to understand about calculating this probability, it actually turned out to be more complicated than I at least anticipated, because it's actually a function of three different variables. One, you have to know the likelihood that the court, in the event they find liability, that the court will find willfulness. And then on top of that, not all willfulness damages convert into enhanced damages. And in fact, what the limited number of studies all consistently find is that when the jury finds willfulness, many, many times, in fact, close to a majority, depending on the time period, they refuse to award enhanced damages. And then the third thing that you need to know is that enhanced damages, what's the multiplier? 3 times is infrequent. It usually hovers a little bit below 2 and above 2. Okay, but what we do see in the limited data, and it has different qualifications, I won't go into that, I'm going to stop now, is that that finding willfulness in cases in which there is a finding of liability, the patentee has prevailed, they seek a willfulness finding, it's not uncommon for the judge to find a willfulness, and that's increasingly the case since the 2016 HALO decision. Okay? But it only sometimes converts into enhanced damages, especially if the jury has found willfulness. And enhanced damages, the court usually does not choose 3 times, and our kind of back of the envelope calculation here, okay, not absolutely precise, is that if we took all of the fully adjudicated patent litigations, the likelihood that the infringer or the defendant will face enhanced damages based on 2 different studies at 2 different time periods are about 10% once you take out the litigations that there's no liability, the litigations there's no willfulness, and the litigations that have liability, have willfulness, but don't have enhanced damages. You get to a fairly small number, and that is consistent with that does suggest that the theoretical circumstance that we identify where it's rational to infringe, in fact, does exist in a significant number of cases. And why otherwise would the head of licensing at Apple tell us that they do that? David, I'll leave the rest to you.
Okay. Very good. Thanks, Jonathan. So great place to pick up and great job. Let me just start by saying thanks to Sean and the C-IP2 folks. This is a great conference. I really enjoyed the morning. Just picking up where Jonathan left off, if you're in the trenches like I am, advising clients on the defense side or the offense side of these litigations, most of which settle, by the way, you have to give the advice, which is that if you're a defendant facing a patent infringement claim, it's very unlikely you're going to face any consequences of enhanced damages. And that's the advice that people give. That's certainly the advice I give. And if I'm on the other side, the plaintiff side, the advice I'm giving is don't plan on getting any enhanced damages. You're probably not. The best you're probably going to do is to get the royalty that you would have gotten in the first place anyway. And that feeds into that vicious cycle that Jonathan is mentioning of just bidding prices down. So a reasonable royalty actually becomes a depressed reasonable royalty, and the entire IP system becomes devalued. So to go into a few additional concepts here, what does this all look like in action? It looks like the FRAND commitment in US and UK, in Europe, there basically is very little possibility of injunctive relief. There's, of course, as we learned this morning, potential antitrust liability, which is advice that we do have to give to clients just for seeking an injunction. So there's another depressive effect. And so how does this then play out in reality? Well, the licensees of SEPs, implementers, routinely decline to take licenses, and they play every game possible to stall negotiations, and I'll give a few examples in a moment. And that in turn compels the patentees, holders of SEPs, to actually litigate despite the risk of antitrust liability. And you get to this unwilling licensee, FRAN compliant offers exception dichotomy that is being played out in the courts now on a regular basis. The third, component of how this is playing out in reality is that the bargaining positions, just frankly, are not at all balanced. You get results and you get parties working together to solve problems and avoid litigation or resolve litigation when bargaining positions are fairly equal for whatever reason. And you don't get results when they're highly unequal. And when the infringer has the advantage of impunity and an interest-free loan for extended periods of years, that is the definition of a very asymmetric bargaining position. And that's why we're seeing what we're seeing, which is having to resolve these cases in litigation and not being able to resolve them through negotiations. So the last component of, so how this is working in action, how it's playing out, is this point of the royalty rates being much lower than they otherwise would be because the defendant, the implementer, just has no reason to embark on a regular negotiation, and there's no way to correct for the fact that the rates are depressed because of the dynamics that Jonathan mentioned. So let's take a few examples before we move on to the solution that Jonathan and I are proposing. How is this actually playing out in four specific cases? The first one, Core Wireless, a Eastern District of Texas case. And in that case, LG, right, Korean company, was engaged for about 2 years, I think over 2 years, in licensing negotiations. They abruptly ended the negotiations. There's a sort of a backstory where they induced the Core Wireless folks to fly over to Seoul on the premise that there'd be a reasonable economic offer. And then when the Core Wireless folks got there, they were instead given like a curt one-page document that said, we decided we'd just rather litigate. So you can imagine you'd be pretty upset after you flew all the way over to Seoul and you get that kind of greeting. And so that resulted in litigation. The defendant in court took the position that, look, infringement is expected as part of this standard setting model. It's okay for us to just like walk into the grocery store and take all the stuff that we want with us and leave and let the grocery store come after us and sue us. And then later, maybe we'll pay them what we would have paid them anyway. In our business, it's just okay to just steal from people. That's what everyone expects. That was essentially a key part of their defense. And so you could see the result, rather puny, $5 million in damages and $465,000 in enhanced damages. To Jonathan's point, that's a little less than 10%, kind of pocket change, right, in the business world that we're talking about. Take the Qualcomm versus Apple case. Pretty famous litigation that settled now about a couple of years ago. During that particular litigation, of course, Apple never had any risk of not having access to Qualcomm's technology. So it got, again, a long-term interest-free loan, no realistic risk of an injunction, no downside for continuing to have the product in the marketplace, an unlimited budget for litigation. So this sort of ticks off all the boxes that Jonathan was giving to you before. Of course, the case settled, and it really was notable to those of us who followed it to see how asymmetric the bargaining position was. Just look at what happened to the stocks of the two companies immediately after the settlements. Qualcomm stock rose a stunning 23%, and Apple stock was essentially unchanged. That's how you know there was extremely unequal bargaining position. Third example, Unwired Planet versus Huawei. So here the negotiation stalled over an NDA, the non-disclosure agreement. Now for context, NDAs are usually a few pages long. Where I work, we delegate that to first-year associates, kids straight out of law school, and they can negotiate NDAs all day long, right? This is not difficult stuff to do. These guys hung up over the NDA. They couldn't put the NDA in place. That's when you know, right, holdout is occurring, when you can't get an NDA done. Eventually, Unwired Planet had to file a lawsuit. Then you find out that the negotiations, even during the lawsuit, continued and were unproductive. In this case, the court eventually found that the infringement merited an injunction. So it's a bit of an exception that proves the rule here, an unusual case that did result in an injunction on the basis of an unwilling licensee. And even though there were SEPs involved. So that brings us to the fourth case, Optus Wireless. And this one is still going on. It's in the UK, of course, as you can see, where Optus initially tried to license this technology. They spent 2 years. That seems to be about the litmus test. After 2 years, folks get frustrated and eventually filed suit against Apple. In the U.S. counterpart suit, the jury found willful infringement. The judge declined to enhance the damages. This again goes to Jonathan's point, where what we found when we started looking at the data is that there's a very imperfect match between willfulness and enhanced damages, and there's a very imperfect match between enhanced damages and any particular multiplier. 3x is definitely not the rule, if you thought that was. And so in this case, Optus was awarded a big result, but the case, of course, is still going on. In the US, it was awarded a big result. The case is still going on in the UK, so it's unclear how that's going to end. But what we can say is that this unwilling licensee exception could well apply to Apple, and we'll see where that goes. So you get a sense from these four cases, just a smattering of how the holdout tactics are actually working in reality. Okay, so Jonathan said that I was going to be constructive. Now I'm going to be constructive. What's the solution? What do we do about this? So what we think we do about this is that we recognize that rational infringement is exactly what's happening, and it is becoming the rule. It has become the rule. We can't change eBay in this country in any practical way. We're not going to be able to get legislation that I can see on the horizon or even over the horizon to create any kind of a presumption of irreparable harm again. So we've got to go in some other direction. And the direction that we're proposing is a new requirement, so a change to the law that requires that courts must award some level of enhanced damages in any litigation in which there was no realistic expectation of an injunction. So this would say enhanced damages, instead of becoming the exception, becomes the rule, and the court's job then becomes to reset the playing field to account for the fact that the patentee had to wait for years, that the implementer, the infringer, got to use the technology for this period of time, and the court's job then becomes, in part, to correct for that. And the enhanced damages then would take the place of or counter for that missing injunction threat. It would cause implementers to have some skin in the game and some incentive to actually negotiate and come to a consensual agreement rather than forcing litigation. Now, you should be concerned, we certainly were and are concerned about not going back to the bad old days when an excessive amount of, I'll call it opportunistic patent litigation was occurring. But there are ways to correct for this, and it's not that difficult. Tops on my list, although second here, would be that courts get charged with adjusting the damages multiplier. Courts are good at doing equity in this sense and seeing into and through situations where defendants had a good faith belief, for instance, that they weren't infringing. And there were good faith efforts that were undertaken to enter into licenses. And imagine the incentives this would create for defendants to actually come to the table and exhibit good faith rather than what we're seeing currently in the holdout environment that we currently operate in. And then there's also the approach, which is tried and true, of offering defendants the opportunity to go out and conduct a good faith litigation or pre-litigation study to a diligence in effect, and it provides some sort of a safe harbor as part of this prong of the analysis to enable a clearance study, infringement study, validity study as a way to either exempt from enhanced damages or at least get the court to take that into account in lowering the enhanced damages. So I'll stop there and just say that we're living in a world in which incentives for patent infringement have become really strange. And we need to accept that as a fact at this point. The economics make it so that as a lawyer, whether you're in-house or at a law firm, you can't advise your client to take a license in many, many situations. And we need to come up with a way to correct for that, to rebalance incentives, to enable lawyers to give their clients advice to take licenses, and enable patentees to know that they've got some leverage to get licenses in place, and a required enhanced damages regime in the absence of an injunctive regime, which is the world we're living in, is a very viable way to do that. So I'll stop there and turn it over to Ann.
Thank you all. I'm going to make some comments on your presentations, and then we're going to turn to the discussion, and I'll be weaving in questions from the online audience as well. So before I forget, though, the CLE code is TRIO. That is T as in Tango, R as in Romeo, E as in Echo, and O as in Oscar. So stepping back a little to put this efficient infringement problem into the broader context of today's debate, I wanted to remind the audience on why holdout can be different from regular old patent infringement. First, many of the efficient infringement cases deal with patent portfolios and not individual patents. That's clearly true when we're talking about SEPs. But courts don't allow you to litigate a portfolio. You can only litigate a handful of patents. In my experience, that number is usually around 5 or 6, not the 200 or more that's in a SEP portfolio. And that has some practical implications for this efficient infringement strategy that go back to some of the earlier discussions about sequential litigation, having to go jurisdiction by jurisdiction, giving, I think, even more asymmetry on the infringer or implementer side because you can impose greater costs. Second, global. Many of these portfolios are not just one jurisdiction, but they're global. And that means you're not just dealing with Delaware and Texas or California, but also UK, India, China, God knows where else. So even if you prevail as a patent holder part party found to infringe can then argue, well, I only need to take a license to those patents that have already been adjudicated, that have been proven to be not invalid, proven to be infringed. Forget the rest of your portfolio, so I'm only going to pay you a fraction. I think yet another factor that further underscores this asymmetry that you guys were talking about is the rules for calculating what damages are. And under traditional patent infringement cases, the U.S. Code at least says that upon finding for the claimant, the court shall award the claimant damages adequate to compensation for the infringement, but in no event less than a reasonable royalty for use made of the invention by the infringer. So in plainer language, reasonable royalties in traditional patent cases provide you with the floor or the lower bound. In contrast, when you're talking about SEPs and you have a FRAN commitment, so this can be, what was the term, standard declared patents, so SDPs as well, which have a FRAN commitment to them, reasonable royalties provide the cap or the upper bound because you can't go above reasonable. And so you're talking about even greater shifting if you've then pushed what that reasonable level is down. You're restricting and pushing undercompensation even further, I would argue, which also makes this efficient infringement strategy far more attractive. Lastly, touching on something that Kristen pointed out, we have to pay attention to population effects. So you made the point that you know that people aren't seeking injunctions as much, and so it's not enough just to look at the grant rates. Because that assumes that the proportion of litigants seeking an injunction both before and after eBay are the same. We know they're not. But I would argue it's also not enough just to say, I know there's selection bias in here. You need to present the statistics. You need to say, okay, before eBay, from reading the case law, here's how many people were seeking and in what circumstances, and post eBay, here's what they are, and show how that has shifted over time. And even better, if we could conduct qualitative research to reach out to some of those parties and say, why did you not seek? Here's an anonymous, check the box. You don't have to give away any business secrets. Collect some data on that so we can then show the unintended consequences of these policies. And I think that would go a longer way to understanding how it's harming. Because just as we've been reminded in the pandemic, dropping out of the labor market is a big deal. It means there's systemic problems in the labor market, and it signals greater problems. So dropping out of the seeking an injunction market can be a signal as well, and maybe is reflective of a rippling all the way back to the R&D phase, where if I know I'm not going to get a fair shake in the courts, I'm not even going to bother. And as an economy, as a society, we should care about that a lot. So, the more you can dig into those numbers, the better. Okay, so now on our panel discussion, I wanted to start with one that came up on the Q&A. Let me just find it again. So the question was, doesn't the enhanced damages proposal mean that the standard is no longer a reasonable royalty, but an enhanced royalty? So thought you all might want to chime in on that.
I would say no. The standard is the real reasonable royalty and not a depressed reasonable royalty. And the court, by making transparent and explicit what it's doing to enhance the reasonable royalty, would ensure lack of conflation between the real reasonable royalty and the enhancement that's added to it, similar to what you already see in court decisions that include willfulness and enhanced damages.
Well, did you want to chime in too?
The only thing I would add, which is somewhat related to the question, which is kind of something interesting that we found, is that our proposal is actually quite old. So in the first few decades of the U.S. patent statute, for various procedural reasons, it was difficult to secure injunctions in federal courts. And as a result of that, it was not only optional, it was mandatory for courts to award enhanced damages. And the origin of the treble damages concept was actually to limit their discretion. You can only go up to 3 times. It's only later that became optional. I just point that out because precisely the reason why they mandated super compensatory damages at that time was the absence of the injunction, the exact same system that we live in right now.
And I want to add to that briefly, and then we'll go to you, Scott. When you're talking about distorting negotiations, the beauty of your all's proposal is that you have very clearly, here's the reasonable royalty award, and here's my multiplier, so now I still have data on what is reasonable for the use of that technology, but I also get the pop that makes up for the lack of the injunction. So I think there's some clarity there, too. So, Scott.
Thanks. All 3 great presentations, and thank you. I would offer 3 thoughts that I hope will help, but I recognize I don't know how they specifically fit the papers, but maybe they give opportunity to make like a new application of the insights you're offering. So one of them is to just reflect. A lot of times in my role mediating, I'm asking the parties, gosh, folks, like, what is your best and worst alternative, right? What are you really spending off of? And one of the things I notice in that setting is, I think you each put it slightly differently, this notion that it's not just a low royalty, but like a royalty on a low royalty, a percentage of a percent. So the way I hear it sometimes in those discussions in the room, so to speak, is folks basically say, sure, I'll even pay, 10%, not just 3%. But it's 10% of my litigation costs, not 10% of whatever my product is. So they've, in effect, shifted as their royalty base. So their royalty base is no longer the stuff. The royalty base is the cost of litigation. And I'm wondering if you're seeing that, and then if your models or your papers could be adapted to address it. I wish I had a convenient suggestion, but that was one, let's call it inflow of information, which is their frame of reference becomes litigation cost. The second one is their access to capital is no longer even primarily internal. So it used to be like, am I profitable? Do I have cash on the books? Now there's a litigation funding market that's so liquid right now that on both sides of the V, on even components of the litigation, it can be quite profitable to be in the business of litigating an issue in the litigation funding market for both the client and the lawyer, even if you lose everything else in the case on either side. So again, I don't know how that ultimately shifts things, but it's a big factor these days. And then the last one is internal costs rather than internal profit, right? Because if I know I have to pay boku buckaroonies tomorrow, but tomorrow's 5 years from now, and over the arc of those 5 years, aw shucks, my profit went down because my salary went up, then I am happy doing the Snoopy dance, even though my shareholders are doing the frowny dance. And that can all happen in these models. So those were 3 takes. One was let's call it the cost of litigation. One was litigation funding. And the last one was, aw shucks, I lost my profit.
Any comments? No? Okay. I'm going to exercise my prerogative as the moderator because I want to step back for a minute. It's very easy to get sucked into these debates of hold up and hold out and efficient infringement, et cetera, with losing sight of what our big picture goals are. So I would like each of you to weigh in on what you think a sensible, internally consistent IPR policy's goals should be, and how your various proposals or research inform that or enhance that or move that goal along?
I didn't offer a proposal, so I can't answer that
Well, you
last
can
piece.
bail on this one if you want.
No, I mean, I can tell you ideally what I would like, but I don't have a proposal that would get there. I really think that and we heard this multiple times today, that we're putting thumbs on scales. And so I think that any sort of valid IPR policy has to be one that sets in balance both the implementers and the contributors, and without putting the thumb on either scale. I think it would be very wrong to flip the scale and say, no, okay, contributors, 10x reasonable royalty, which is not at all what they're suggesting. But that I think would be just as harmful to the space as where we are right now, which seems to be that the thumb is on the implementer side of the scale. So I just would seek balance.
Jonathan?
Sure. If I had to pick one main objective, I think the fundamental function of an internally consistent and economically sound patent system, or even IP system more generally, is simply to create a market in novel technologies. And novel technologies require property rights to do that, just as tangible goods do, but they actually need them even more. Because they are easy for unauthorized users to use them without seeking permission first, as opposed to moving into someone's house is a little bit more difficult without negotiating a lease first. The reason that I want to say that the fundamental purpose is to make a market rather than to incentivize innovation is because making a market captures incentivizing innovation, but it captures a lot of other things that I think are overlooked. When you have a robust IP system, you not only incentivize the invention of the CDMA technology behind the smartphone, you also incentivize not only the smartphone, but you incentivize a wealth of business models that are based on that. You incentivize Uber, you incentivize Lyft, and so forth. You get this market multiplier effect, and you get huge gains in dynamic efficiency that I don't think there's any doubt that they are far greater than any extremely short-term gains you would get in static efficiency if you were to abolish intellectual property rights over everything that exists right now.
So, yeah, and I would just add, coming back to your big picture on SEPs, what I would like to see is more for the U.S. to make more of a move toward what has been recognized in Europe in general and in Germany in particular, which it goes to balance, but it also goes to putting the same onus on the implementers as on the innovators. So this means conducting negotiations with a sense of urgency, like you really want to get something done. And again, our proposal will cause that to happen because people will now recognize if we don't get a license in place, it's actually going to be kind of bad to litigate. I think, again, the Germans have done a relatively good job at recognizing that there are just as many tactics that are being undertaken by implementers as innovators, maybe more tactics by implementers than innovators, and that a system that works is one that puts real teeth in its incentives to come to the table, negotiate a reasonable royalty rate and other terms and conditions. And I think that's fundamentally what's missing from the U.S. right now. Our laws become very muddled, and there just aren't enough good decisions at the district court and federal circuit level that recognize the importance of that balance and putting the onus on both parties, but really especially the implementers who have not had onus on them.
Yeah. So we have two questions in the room, but I'm going to do one online that came before you guys. I am a component manufacturer and not interested in efficient infringement strategy you have discussed. My component implements a standard, and I would like a license from the SEP holder, and I'm a willing licensee. The SEP holder is refusing to license me and instead would like to license a downstream manufacturer. What am I supposed to do as I am being forced to be an efficient infringer? Anybody want to?
I'll just start. I'm sure that Kristen and Jonathan will have comments on that. But I think the Ninth Circuit is your savior because they said it as pithily as I can imagine saying it. And it's not a matter of, no license, no chips. It's a matter of no license, no problem. You could just dance your way to put your product in the marketplace. Don't worry about it. The licensor that is ignoring you is doing that for a good reason. They're going to place their license elsewhere. Not only is it their right, but it inures to your benefit. You don't need to worry. No license, no problem.
Well, I would add to that because of exhaustion. That patent holder is not going to come after you. You can be pretty comfortable about that because if and when they do, they lose their ability to license later on. So, okay, Nick, and then.
Thanks. One of the traditional justifications for injunctive relief is the difficulty of proving damages, and we've seen that in spades at the Federal Circuit in recent years, where you get a lot of damages cases reversed, even if you win, and even if you win a good royalty. I'm not sure that that's something that your proposal, Director Kapos and Professor Barnett, addresses. But in the trademark realm, the statute actually flips the burden of proof, and the trademark owner just has to prove the defendant's profits, and then the defendant bears the burden of proving, disaggregating, what they got from the trademark infringement versus what they got from the other aspects of their business. Might that be another way to skin the cat and address some of the difficulties within the no injunction world?
So I'll take the first part of your question. I think that our proposal indirectly addresses that because if the enhanced damages are sufficiently high and the likelihood of being hit with those damages are sufficiently high, then we would have successfully mimicked the restoration of the injunction. And in a world with an injunction, what's going to happen is that parties are not going to willfully infringe anymore. Instead, they're going to start to negotiate, and what then happens is that we approach the big picture objective of an intellectual property system. We restore the market's ability to price out those assets, and hopefully we would minimize the cases where judges have to do so imperfectly. And in fact, what would then happen is that even in the limited case, in the reduced number of cases where we would have litigation, the judges are going to do better because they're going to have a much more robust and more accurate sample set to draw in trying to find the comparable royalty.
I mean, just one thing I would add, interesting thought about mimicking the trademark regime, not something that we tried to address and not something I've thought about in this domain, but it could be the subject for another paper by a great academic.
Okay.
Hi, John Kolakowski from Nokia. What do you think of the idea that a royalty for an adjudicated, valid, and infringed patent should be higher than the royalty prior to such adjudication? I know that there's obviously a problem in that our damages law suggests that a royalty should be determined at the time of first infringement, the hypothetical negotiation that takes place before all of this. But is there a way or a scheme or a system in which we could eliminate or counter this efficient infringement idea by upping the royalties if the litigant, a patent holder, has to go all the way through litigation and therefore has proven that its patent is perhaps worth more afterwards than it would have been before?
Okay, so I could start. I mean, I would tell you that's precisely what our thesis is and what we have in mind is that, you as a patent holder of an SEP, you have to chase the infringer, go through an entire adjudication. You obviously have to show that your patent, you have to withstand a challenge to the validity of your patent. You need to show affirmatively that it's infringed. What we would say is the court then is duty bound to reward you And one of the things they'd be considering is the fact that the infringer could have taken a license earlier, forced you to go to litigation and spend all this effort and money. And so that, in my mind, the factors that you're articulating in your question are among those, but there would be others that a judge would be required to consider in her or his mandatory enhancement of damages.
And the one other thing I would add to that, and I thank you for that question, because it actually gave me a thought, and I think we will add this to the paper, is that the enhanced damages and the multiplier used, and if we take into account the factor that you mentioned, what it would probably, you not only induce more licensing and less litigation, but you'd actually get a sort of an efficient sorting effect between what I would say good infringers and bad infringers. And what would be a good infringer? A good infringer would be someone who thinks that the patent is not good, that the patent's invalid. And in fact, I would acknowledge, maybe David would agree, that actually we don't want to disincentivize those infringers. We want them to challenge the patent. And so if we take that factor into account, then it would help to screen out those who are infringing under the full knowledge that there's no doubt about the validity of the patent.
Yeah. John?
Yeah, John Putnam, Competition Dynamics. On that last point, isn't it the case that the law is that the royalty rate for a valid and infringed patent should be higher than the royalty rates found in licenses before the patent's been found valid and infringed? The empirical problem is trying to prove how much higher it ought to be. So I've run into all kinds of problems, studying success rates of patentees at trial and using that as a proxy for the discount that you observe in a license, which should be removed post-trial for a valid and infringed patents. And, judges say, well, that doesn't fit the facts of this case, as though there's such a thing as a case-specific probability, which is, maddening. But anyway, what I wanted to, so it can be done, it's just complicated. My question really was, what you guys are proposing, which I completely favor, but it actually requires a change in the law. What would be your reaction to a private litigant, and this is specific to the SEP context, saying, we promised that we would license our technology on fair, reasonable, and non-discriminatory terms, and so you get our technology at the same price as everybody else. We did not promise that the overall royalty rate would not reflect the cost that you impose on us as a result of your infringement and as a result of holdout. So we're going to calculate the position that we would have been in had you not held out. We're going to take into account the time value of money, the distortion of our existing licensees, the depression of the market prices, and everything like that. And so we're seeking a higher royalty rate post-trial, not on the grounds of, not to violate our FRAN commitment, but on the grounds of compensation, because you impose additional costs on us in the way that you went about this negotiation, and all we want is to be made whole on those grounds. And then if you are holding out for 7 years, the royalty rate is increasing over time, and so it isn't this costless thing of, I can always get the FRAND rate. It's, I get the FRAND rate plus all the costs that I imposed on the patentee. So my question is, as lawyers, what's your reaction to that in a FRAND environment? How would you think that judges would support that or not? And I'm interested in anything else you might think.
Well, do you mind if I?
Yeah, no, please.
Well, I think that's consistent with the underlying rationale of FRAND, the underlying history of FRAND. In a paper I published a few years ago, I went through the history of FRAND, and the FRAND requirement actually emerged in the initial negotiations between Motorola and the Scandinavian countries who were rolling out the first telecom GSM cell phone network. And the telecom carrier's position was that the royalty should be zero. Why did they say that? Because telecom markets in Europe up to that time were each national monopolies, where you had a national telecom carrier and a national equipment manufacturer. And Motorola, of course, said that was inconsistent with business rationality as the IP holder and not a telecom carrier. Why do I point that out? Because we always talk about FRAND as being there to protect the telecom carrier. Actually, FRAND was the result of a negotiation to assure a positive royalty that would fairly remunerate the IP owner in that case. And so I think this, this modified interpretation in FRAND in a no injunction environment, I think is perfectly consistent with the rationale behind it and the history behind it.
And I just add, I love the idea of including in the obligation on judges to enhance damages to take into account the time, number of years, the egregiousness or not of the holdout, the costs imposed on the licensor, the litigation costs, John, which I don't think you mentioned, but I would love to see all of those taken into account.
I'm wondering if particularly Jonathan or David can address efficient infringement in an international context. Civil law jurisdictions don't have eBay doctrines. Does the availability of injunctions overseas affect the efficiency of the infringer? And also, how much has it been affecting the attractiveness of the U.S. as a jurisdiction to litigate SEP disputes?
My own perspective, Mark, is that the availability of the injunction in places like Germany, as an example, clearly is an important factor and counters the issue that Jonathan and I have been working on with finding a way to enhance damages. And to your second question, Germany is a good example as well, that the availability of injunctions there has made it an extremely attractive place to bring patent litigation, and the lack of availability has made the U.S. a less attractive place. Again, as someone who's in the trenches giving this kind of advice to clients, I will readily encourage them, if they've got an international dispute, to make an early filing in Germany and to think about the issues and the advantages and disadvantages of filing in the U.S.
Yeah, so there's also an argument on the policy side of favoring some kind of remedy against efficient infringement. Otherwise, the U.S. loses control over these cases.
You lose control and you even lose relevance.
Right.
I know we're running up on time. I wanted to end with a question related to SEPs, and in particular, the ND part of the FRAND commitment. How does efficient infringement, it's clearly focused on the fair and reasonable elements, but ND has to come in here, right? Because we're talking about licenses not just to one party, but to numerous parties. And also the enhanced damages, how does that play into the ND part? So I'd like to hear your thoughts on that. Okay, well, we're going to start with Kristen then.
I feel like I'm playing euchre. It's hang the dealer time or something here. Nobody wants to answer, so I will.
I warned you of this question in advance. You have no excuse.
I left my papers at home.
The dog ate them.
The dog ate them. No, I mean, I think you're right. I think that the focus thus far has really been on the fair and reasonable. But I think the problem with the non-discriminatory, especially when it comes to maybe the enhanced damages issues, but I think that there's a conflation between same and non-discriminatory. And I think that's really, it might be to our benefit that we haven't focused on the ND if the judges are going to take it and say, ND means the same for all parties, competitor, no competitor. You know, that some of that's what comes up in the injunction discussions is, are you a competitor, are you not, do you practice, do you not? And if we're going to make ND equal same rather than what it should mean, I would be very concerned, and maybe we should just not focus on ND.
Well, it's a hard question to. The reason I'm hesitating is because it is, I think, as your question is suggesting, and as Kristen just observed, it is the part of FRAND that has received the least attention, not just in the academic literature, but in the courts. And I think that's not only a question of lack of attention. It's perhaps it's perhaps one of the harder part of FRAN to understand how to implement that consistent with economic efficiency. So I don't have too many additional thoughts to say about that, other than to agree with you that I think it is an area where it would be helpful on the academic side, the consulting side, to think about that more deeply, so that courts have better tools to understand how that can be understood in a way that's consistent with economic efficiency. What we do know is that it cannot possibly mean that all parties get exactly the same terms. There's a licensing market couldn't possibly function based on that principle.
And actually, at least in my experience, courts have not said, oh, they have to be the same. But actually, I would argue that this is a plug, the ND part of FRAN is a plug for your proposal, because if you have an always get an injunction rule or a never get an injunction rule, you are creating some asymmetry in the bargaining. That can push rates either too high or too low, and then, as you noted, when those are too high or too low, it perpetuates itself through the court damages and also through the next round of negotiations for the next license. The thing I liked about your proposal so much was I think it gets to this issue of non-discriminatory, in that if the rulings have transparency and it's not all rolled into here's your number, you have what a reasonable royalty is, and you have information on what the multiplier or the add-on for the costs imposed are, and those two things are reported separately. And then you have greater information going forward for negotiation purposes on what a fair royalty is and what the cost will be to you if you choose to infringe and are found guilty. So I was trying to give you a softball, but I'm going to, I'll pitch it for you. So,
So I'll just react to that a little bit. Excellent point. And the way I was thinking about it, Ann, is that while the non-discriminatory component of FRAN is important and must remain important, its enforcement needs to be normalized in some fashion for the behavior of the infringer. And I think that's what you've just stated in a more articulate, I don't know, a more objective way, by splitting out the portions of the award, so you're able to say this is the non-discriminatory royalty you would have gotten, but you actually have invited some discrimination by dint of
broke the rules. Didn't behave in good faith.
You held out, yeah. And so there is a discrimination, whether you call it by that word or a separate compensatory.
An economist would not call that discrimination. I mean, you have a different circumstance. You have behaved badly.
Right. So you'd say it remains non-discriminatory. This additional component is part of what compensates and ensures non-discriminatory treatment, even though you're paying more.
Right.
Okay.
Right. Do we have time for one more? Because there's one online. No? Okay. On this non-discriminatory point, shouldn't the SEP holder be held to the standard and be asked to license any willing licensee, even a component manufacturer? I think this is the same question we've already answered. Otherwise, it could be construed as violating the ND aspect. I mean, as an economist, I would say no, because you still have access. The non-discriminatory part is access to all. You don't need a license. You can have the non-assert. I don't know if anybody wants to add anything.
I mean, I would just add that we need to be honest about this discussion. It's a discussion about devaluing the intellectual property because of the point that you made earlier. And I mean, everyone realizes that if the IP is under current exhaustion regime, which I vehemently disagree with, but the Supreme Court has a say on this, if you license at the component level, you have almost certainly exhausted your patents, and you can't license them then at the device level. So what I would expect would happen if the sought-after component-level licensing regime became de rigueur would be, and this is what I used to do when I was doing direct line licensing 30 years ago, was you charge one non-discriminatory rate for licensing at the device level, and you charge a different non-discriminatory rate. When I was doing it, it was 5X. For those of you who want to have component-level licensing, 5X was the market rate for licensing at the component level. So that's in practice, that's what would happen, or you would just have another market devaluation of intellectual property licensing.
Yeah.
That's the honest truth of it.
All right, thank you all panelists. That was excellent.